Please be seated. The court is now back in session, and again the chamber is handing the floor to the Deputy International Co-Prosecutor to put further questions to the witness, Mr. Richard Dudman. You have the floor.
Thank you, Mr. President. Mr. Dudman, we very much appreciate you making your effort to testify here as a 96-year-old. It's an amazing thing. I'm going to continue reading some of the things you wrote from your trip. I realize that you may not remember too much at this point. Some of the statements you've made, though, are of quite interest to us, and if nothing else, we want to make sure they're part of the record here. And I will continue to ask you some follow-up questions, and hopefully maybe some of this will spark some recollections. I'm going to continue in an article that is titled The Enemy Vietnam. This is in E3 3290 at English ERN 00419-207, Khmer 01070696. And here's what you wrote. I quote, "Throughout the visit, officials denounced the Vietnamese continually, as did Radio Phnom Penh, as fascists, false communists, aggressors, the Cubans of Asia, country swallowers, and crocodile, a most ungrateful animal which does not recognize as master the person who feeds it. The foreign ministry official who toured the country with us took us to a zoo at one point, said, 'Come see the Vietnamese prisoners.' He led the way to a pit with 60 big crocodiles in it. At another time, the official said with a straight face that all Vietnamese army officers have 3 wives, one in Hanoi, another in Saigon, and the third at the front." End of quote. Do you remember your reaction when you heard Democratic Kampuchea officials making remarks like this about the Vietnamese in your presence?
Well, as a journalist, I figured that was a nice nugget for a story, and I put it in because I thought it would both amuse and enlighten our readers.
Mr. Dudman, I want to read to you now a couple of examples from DK radio broadcasts during the time you were in the country in December 1978. Your Honor, these are from E3/295, the FIBIS records for December 1978. At page 00169-107, this was a broadcast on the 16th of December 1978, which reads as follows. According to sources in Vietnam, the Le Dun Pham Van Dong troops are more barbaric, fascist, and puritanical than those of the former Chu Ki regime. Continuing in the next paragraph. In early November, a soldier wearing a 1-star rank insignia cut off a woman's hand to rob her of a gold bracelet. And then continuing in the same paragraph, worse still is that the Lee Duan administration has ordered each southern family to give room and board to a soldier from the north. These soldiers can loot the people's property at will. They have even raped in a most barbarous manner the wives of the head of the families with whom they live. End of quote. A broadcast on the 21st of December 1978 by the Phnom Penh radio. This is at 00169-159. Quote, the skinny and wounded Vietnamese dog has been so infected by the virus of defeat, insanity, and famine that even its Soviet masters cannot help it. This skinny and wounded Vietnamese dog is now becoming even skinnier and will soon die. End of quote. And last, on the 18th of December 1978, at 00169-135, there was a broadcast of a confession, a purported confession, of a female Vietnamese spy. States, the confession of Ly Thi Vinh Sang, an espionage agent of the Vietnamese aggressors captured by our Kampuchean Revolutionary Army in Svay Rieng Province on the 25th of September 1978, clearly shows that the Vietnamese Ly Duan clique has committed most cruel and savage acts against the Kampuchea Krom minority. They have strangled babies to death and given lethal injections to mothers who had just given birth. End of quote. Mr. Dudman, I read to you these excerpts. My question is a simple one. Is this the same type of anti-Vietnamese rhetoric that you heard while you were in democratic Kampuchea in December 1978?
I think it's the same thing. I wish I had heard that one at the time. I could have used that.
Do you remember, did you ever review FIBIS reports of radio broadcasts from democratic Kampuchea, or do you remember how it is that you became aware of what was being broadcast by Radio Phnom Penh?
I don't recall knowing about those broadcasts. Maybe I did, but I don't remember.
In the first two paragraphs of Article E305/12.54, E305/12.54, you reported a statement made by Pol Pot on the 22nd of December 1978, which is the day you met with him. You and Ms. Becker met with him. And this is what you wrote that Pol Pot said. Pol Pot said that 95% of the people in democratic Kampuchea were good, that they had been able to re-educate and recover, in his words, another 4%, and that they were still working on the re-education of the other 1%. Mr. Dudman, do you remember, was this something that Pol Pot said to you during your face-to-face meeting, or do you remember receiving written answers to questions that you and Ms. Becker had provided?
I don't remember how I got those quotes.
Do you remember whether Pol Pot provided any explanation of how he knew the percentage of people in democratic Kampuchea who were being subjected to re-education?
I don't know.
I'm going to now ask you about some specific Khmer Rouge cadres that your group inquired about or were given information about during your visit. In your article titled Governing in Secret, this is in document E3/3290, English ERN 00419-211, Khmer ERN 01070714. You reported that you had been told by a Ministry of Foreign Affairs official, Ok Sakun, that, I quote, Hu Nim, Minister of Information, and Hu Yun, Minister of the Interior, were still active in the government, although believed in the West to be missing or dead. End of quote. And I'm also going to refer at this time to a document E333.1. E33.1, Mr. Dudman, is a 18 December 1978 report that was written by Democratic Kampuchea officials about your visit, and it contains a section titled Additional Requests by the Guests at English 0105-4090, Khmer 0104-7239, French 0105-4094. And in this document, it indicates, quote, the British professor asked about Chao Seng and Fok Chai, end of quote. And I realize I'm asking a lot here, Mr. Dudman. Do you have any memory of the responses that you, Ms. Becker, Mr. Caldwell received when you made inquiries about cadres such as those referenced here?
I don't remember any responses.
For the record, Your Honors, document E3/2285 at Khmer ERN 00009220-23, English 00873-450-461, is a list from the S-21 prison titled Names of Prisoners Smashed on the 6th of July, 1977. It identifies 127 prisoners who were executed at the S-21 prison on that day. Number 123 on the list is Fok Chai, one of the cadres whom Malcolm Caldwell had asked about. And number 125 on that list is Minister of Propaganda Hu Nim, a person that you, Mr. Dudman, were told was still alive when you were in Democratic Kampuchea in December 1978. Do you remember whether you had any impressions during your trip on whether Democratic Kampuchea officials were being honest with you about prisoners, political prisoners in the country?
I don't remember.
In the one of the reports I mentioned earlier, this is again a report from a Democratic Kampuchea official, E3-1156. This is a report that listed requests that you had made for the trip. Number 7, the seventh request attributed to you, Mr. Dudman, indicated that you had accused the revolution of executing people and that you wanted to see political prisons and to be explained how the revolution dealt with political opponents. What was the response you received to your request to be shown a prison or re-education office?
I don't recall what response I got.
Did you visit any prisons or re-education offices when you were in Democratic Kampuchea?
Not that I can remember.
Have you ever had the opportunity to visit S21 or the Tool Slang prison in Phnom Penh? And do you know that this prison is located only about a mile or so away from where you were staying when you were in Phnom Penh in December 1978?
I don't recall visiting that prison.
Your Honors, based on E3/342, which is the OCP revised S21 prisoner list, and E3/1651, which is an S21 interrogation log for December 1978, there were a total of 35 new prisoners who were sent to S21 on the 10th of December 1978. That was your first full day in Phnom Penh on your trip, Mr. Dudman. Those prisoners included 3 female cadres who had been arrested from the Ministry of Foreign Affairs and 8 medical cadres, including a 16-year-old female who worked at a hospital. And on the next day, the 11th of December 1978, while you were still in Phnom Penh, the S21 documents record that 28 prisoners were taken away and executed that day. This is one prison on the first 2 days of your trip. Did the foreign ministry officials who accompanied and talked to you ever disclose to you in any way that people were being arrested and sent to prisons while you were there, or the fact that people from their own ministry, the Ministry of Foreign Affairs, had been arrested and were being detained in prisons in Phnom Penh?
I don't recall being told about that at all.
What's the purpose of questioning Mr. Dutman like this? Obviously, he hasn't been told this. It's just for the purposes of entering into the record S21 documents. We have a segment on S21 coming up. I think that is the more appropriate time and place to do it. It doesn't really help anything, this line of questioning, Mr. President. But the answer was already given, so technically I don't object anymore.
Mr. President, this witness has written about political prisoners, his effort to make inquiries about the status of them. This prison was about a mile away from where he was. I think I'm entitled to ask a few questions related to whether he was provided any access or prevented from learning about what was going on.
President, the Deputy Co-Prosecutor, you can resume your questions. And the Chamber would like to remind the parties again that you can put questions through the witness who are of senior age about all the facts being debated before this Chamber. That is during that witness testimony. You may proceed, Co-Prosecutor.
Thank you, Mr. President. Mr. Dudman, do you remember while you were in Phnom Penh whether you and Ms. Becker were allowed to move freely about the city?
I don't really remember.
Let me read a short excerpt from one of your articles to see if that refreshes your recollection. In E3/3290 at English 00419-207, Khmer 0107-0693-94. This is what you wrote, quote, "Officials warned us against wandering off unescorted, even in almost deserted Phnom Penh. When we slipped away several times, believing the warnings to be a mere excuse to keep us from seeing too much, the guards quickly found us and drove us back by automobile to whichever guest house we were occupying at the time. On one occasion, a guard took Miss Becker by the arm and gently but firmly conducted her home." End of quote. Does that refresh your recollection, Mr. Dudman, on whether you were allowed to move about freely in Phnom Penh?
I read that portion just yesterday, and I can't really place myself back in that situation, but it sort of rang a bell.
Thank you, Mr. Dudman. Yesterday, Noon Chea's counsel spent some time with you on your August 1990 op-ed piece in the New York Times. He read to you a statement in the fifth paragraph of that article, E307/5.2.16, which referenced the conventional wisdom that Pol Pot and the Khmer Rouge were irrational fanatics who practiced deliberate genocide, conventional wisdom that you were questioning. Towards the end of that same article, I'd like to read another quote to you. You wrote as follows, quote, "But what about the killing fields and the stacks of skulls? The remains of a few hundred victims are undeniable evidence of mass executions, but they have no bearing on the question of how many were slain and certainly do not prove genocide. My own conclusion is that Pol Pot is not an irrational fanatic, but a revolutionary leader who was riding a tiger, a violent, disorderly uprising by poor, ignorant, downtrodden country people. Deeply resentful of urbanites, they had no compunction about driving city people into the countryside and letting them die or even clubbing them to death if they fell by the wayside or couldn't stand hard manual labor." End of quote. I have just a couple of follow-up questions to this, Mr. Dudman. When you wrote this op-ed piece in 1990, had you had the opportunity to review the surviving records from the S-21 prison in Phnom Penh, records which showed that over 12,000 people had been killed at that prison alone?
I don't believe I had that information, but I don't recall.
You testified yesterday that since the time you wrote this article in 1990, you have consulted news sources and read materials that has caused you to change your conclusions about the occurrence of genocide or mass atrocities during the Khmer Rouge regime. Can you tell us some of the sources that you have read or people that you have talked to since 1990 that led you to change your opinion?
I guess my opinion did change some but I can't really recall what caused that.
We talked about earlier an article you wrote in December 1978 titled Conformity, a Must for Survival in Cambodia. And at the very end of that article, and this is E338.19, you wrote, and I quote, "A reasonable appraisal on balance seems to be that a major factor in the violent deaths, whatever their number, occurring in the last 3.5 years has been the working out of the unparalleled social upheaval of this revolution. Whether the leaders encouraged or moderated the violence or just rode with the tide is hard to say." End of quote. Mr. Dudman, when you visited Democratic Kampuchea in 1978, were you given access to documents by the Khmer Rouge? And specifically, do you remember ever being allowed to review a publication called Revolutionary Flag, an internal document that has circulated by the party that has flags on its cover, something that was sent to the party cadres every month? Do you remember being given access to any documents like this by the Democratic officials when you were in Cambodia?
I don't recall getting any such documents.
Mr. Dudman, a number of the surviving issues of the Revolutionary Flag publication are now in evidence in these proceedings. I'd like to read to you one excerpt from the April 1977 issue of Revolutionary Flag, E3/742, to get your reaction. This issue of Revolutionary Flag published a speech by a party leader on the implementation of the 1977 party plan. And at English 00478-496, French 00499-754, Khmer 000-62986, the following instructions were provided to the party cadres. I quote, "As for the enemies that are CIA, KGB, and UN agents, Vietnamese agents, the cheap running dogs of the enemy that sneakily embedded inside our revolution and our revolutionary ranks, we must continue to strike them and trample them from our position of absolute advantage and must constantly be on the offensive against them during 1977 to smash them even more so they cannot raise their heads." And a few pages later, English 00478-501, French 00499-758, Khmer 000-62991, quote, "It is imperative to indoctrinate and whip up the masses into a force to seek out the enemy, assess the enemy, analyze the enemy, track the enemy, pressure the enemy, capture the enemy, to smash the enemy, and to make the enemy be like a rat surrounded by a crowd of people beating and smashing it." End of quote. Am I correct, Mr. Dudman, that you were not aware of evidence like this and had not been provided these documents when you wrote either your articles in December 1978 or your op-ed piece in August 1990?
I wasn't aware of that language.
Would you agree that this evidence seems to help answer the question you raised at the end of your article, that is, whether Khmer Rouge leaders were encouraging or facilitating the violence there.
It certainly sounds like they were whipping it up.
Another
The prosecutor, please wait, and counsel for Kyo Sampon, you have the floor.
Yes, Mr. President. I speak rarely when questions are put by the parties because I believe that we are professionals and we can be a bit lenient. However, I note that the usage of documents by the International Co-Prosecutor over the past minutes is not really aimed at putting questions, but is close to something like pleadings. I'd like to remind you that Mr. Dudman is a witness. He said he did not know the documents, and he's being put a question, but it's a rhetorical question. So I can understand that from time to time we can dress things up here, but here the prosecutor should put questions based on elements that Mr. Dudman is expected to know.
If I may respond, Mr. President, it was the defense who have put into evidence the 1990 article that made various conclusions. I'm entitled to pursue with this witness what information was available to him, what wasn't, and whether that information would have affected what he wrote in those articles that the defense have put before you.
May I please answer, Mr. President? That's precisely the problem. The witness is asked to speculate. Would you have done otherwise? Would you have put other questions, for example? The idea is not to know what the witness would have done. The idea is to know what the witness saw, witnessed, and with regard to things that he's not aware of, he cannot testify about these. And here we're asking him to speculate. He's not an expert. We're speaking here about a witness, so he should be put questions as a witness.
President, I'd like to hand the floor to Judge Co-Defense to provide an oral ruling on the objection by the defense teams to the question put to the witness by the Deputy Co-Prosecutor. And Judge Friends, you have the floor.
We note that we have given a lot of leeway when it came to the questioning of this witness, also to the Defense Counsel. We have accepted more speculative questions than we would normally have, also for the Defense Counsel. But I think it has become obvious the last 1.5 days that the witness memory is limited. So we would strongly suggest that questions are limited to what a witness is actually supposed to testify to, and this is facts. Frankly, presenting documents, then asking for confirmation that he doesn't know them, and then asking him what he would have done if he had known them, is perhaps stretching the limits of even the leeway the Chamber has given too much.
Am I entitled to confirm whether the witness had access to certain types of evidence when he visited Democratic Kampuchea and when he wrote his articles?
But generally, yes, but perhaps not after reading for minutes pages and pages of these documents. I'm sure this is possible to verify in a more general way.
I will proceed to do that, and then I will wrap up my questions, Your Honor. I was asking Mr. Dudman about another category of documents that are in evidence in these proceedings. And there are about 300 to 400 surviving telegrams and reports that were sent to the party leaders in Phnom Penh from the zones and various organizations in Democratic Kampuchea. A simple question. When you were in Democratic Kampuchea, were you provided access to telegrams and reports that were sent to the party leaders in Phnom Penh on what was going on in the country?
Mr. President, this is, with all respect, a ridiculous question. I mean, no government, even today, would give access to journalists or telegrams or of course, Mr. Dutton didn't see any telegrams.
Mr. Dudman, did you receive any documents like that when you were in Democratic Kampuchea? Had you ever reviewed telegrams or reports like that before you wrote your op-ed piece in 1990?
I don't recall receiving such documents.
I'm getting near the end of my questions, Mr. Dudman. Were you, Mr. Dudman, one of the journalists in the United States who was put on the so-called enemy list of President Nixon?
Yes, I was.
Can you explain to the court what that enemy list was?
I think it's just what it said it was, the list that the Nixon administration considered enemies.
After you were put on the enemy list by the President of the United States, were you arrested and sent for re-education by the United States government?
No, they don't do that.
Did you continue to be employed as the Washington bureau chief of a major U.S. newspaper despite being on Nixon's enemy list?
Yes, it may even have helped my standing.
Based on your observations from your trip to Democratic Kampuchea, What happened to Cambodian dissenters who made the enemy list of the Khmer Rouge leaders?
Well, from what I read, they were exterminated.
The last item I'd like to ask you about, Mr. Dudman, is from document E333.1. This is the 18 December 1978 report that was written by Democratic Kampuchea officials about your visit to the country. And at English 01054091, Khmer 01047240, French 01054095. The Democratic official who wrote this, Democratic Kampuchea official who wrote this, said the following, I quote, "The two American journalists clearly serve the American government and the CIA as we have precisely identified." End of quote. Do you have any reaction to the assertion in this report that you, a person who had been on President Nixon's enemy list, was working for or serving the interests of the CIA?
That's a lie.
Mr. Dudman, thank you very much for bearing with me today with my reading of a lot of documents. The co-prosecutors appreciate very much your effort to testify in this proceedings. Mr. President, no further questions.
President, thank you. And the Chamber would like now to give the floor to the lead co-lawyers for civil parties. You may proceed.
Yes, thank you. Thank you, Mr. President. Good evening, Mr. Dudman. I am Marie Guiraud, and I am representing the Civil Parties Collective in this trial. I'm going to try to take into account Judge Fence's observations and to call upon the memory of the witness and to just stick to the answers he may provide by trying to have him react to a certain number of testimonies we heard since the beginning of this hearing. Mr. Dudman, first I would like to mention a document that was quoted by the co-prosecutor a few minutes ago, and it is this famous list of requests you made to the heads of Democratic Kampuchea who organized your tour in December 1978. And this is document E3/1156. And in this document, at paragraph 2, in which your requests are explicited, you say at request number 6 that one of your requests for this tour was to see the mobile units at work and to see how the cooperatives were organized, and also to visit 2 to 3 cooperatives. So my first question, Mr. Dudman, is, do you remember having insisted to visit cooperatives and to understand how they were organized, and more particularly, do you understand having requested to see the mobile units at work?
I don't recall my request.
Je vous remercie.
Thank you. More generally speaking now, can you tell the court what you remember with regard to your visits of the cooperatives you made when during your stay in Democratic Kampuchea in December 1978? And I will start with the first question. Do you remember the number of cooperatives you visited?
I do not remember that.
Vous souvenez-vous?
Do you remember having visited cooperatives, generally speaking?
No, I don't recall that.
Do you remember in the slightest way having gone with Miss Becker and Mr. Caldwell to Takeo province and to Lebo cooperative? Does the name Lebo ring a bell?
I don't recall that visit.
Thank you. Do you remember in any way having met people working when you toured Democratic Kampuchea in 1978? And if you remember seeing people working, can you tell us what you remember? Can you tell us what you remember of the work sites that you visited?
No direct memory. I have only what I wrote at the time.
Je vous remercie.
Thank you, Mr. Dudman. Can you explain to us what you remember today with regard to the conversations you had with the people you met back then concerning the working conditions in the cooperatives? Is this an issue you spoke about? It appears that that is the case. And if this is indeed the case, what is the information you remember today?
I don't remember getting that information.
Je vous remercie.
Thank you, Mr. Dudman. Mr. President, it is now close to 10. So maybe I will take advantage of this adjournment so I can reorganize my questions and maybe have the witness interact a bit more, in particular by having him react to specific excerpts of articles that he wrote. I think that might be a better way of jogging his memory. So, given that it's 10 o'clock almost, I suggest that we stop now and that we continue tomorrow morning for about a half an hour.
President, thank you. And the Chamber would like to thank you, Mr. Richard Dudman, and the hearing of your testimony today is concluded. However, your testimony is not yet finished, and you will be invited once again to continue your testimony tomorrow. That is Wednesday, the 1st of April 2015, from 8 o'clock to 10 o'clock morning times. That is Cambodian time. That is at the same time as of today. And the Chamber would like also to thank Mr. Todd Lowell and Mr. Jason Barrett for your assistance. And you are once again to be invited to accompany Mr. Richard Dudman for his testimony tomorrow from 8 to 10 o'clock in the morning Cambodian local time. And you may now have a break, and we see you tomorrow.
Thank you.
President, AV unit, please disconnect the link to the video conference. And we have two small matters to be processed. First is a ruling for the request by the prosecution, and second, the concern raised by the defense teams regarding the victim's statement of impact, as well as the closing brief in the case of 001. President, the Chamber will now provide an oral ruling to the request by the International Co-Prosecutor, that is document E342. The Chamber insists of a request filed on 3rd March 2015 from the International Co-Prosecutor to admit into evidence a book titled Brothers in Arms, Chinese Aid to the Khmer Rouge, 1975 to 1979, authored by Andrew Murtha. That is document E342. The Chamber needs to assess if the requirements of Internal Rule 87.3 are met. The Chamber notes that the book is 175 pages long and only available in English, and that the request came at a late stage of the proceedings. To allow for a timely decision, the Chamber requests the International Co-Prosecutor to submit a new request identifying the relevant excerpts within 2 weeks, failing which the request to admit the book will be considered moot. And next, I'd like to hand the floor to Nuon Chia's defense to present their request and their supporting brief. You have the floor, Counsel.
Thank you, Mr. President, and thank you for allowing us to make some oral submissions in relation to a request done by the civil parties in respect of the upcoming civil impact testimony hearing on Thursday and Friday. Yesterday, we sent by email an excerpt from our appeal brief, not our closing submissions, but our appeal brief. And in this appeal brief, in these submissions in our appeal brief, we have argued that in the judgment in case 002/01, an amount of 255 times, if we calculate it correctly, evidence that has been presented during civil impact hearings was used as evidence. And
Counsel Coupe, please hold on. There might be a technical problem with the interpretation. Court officer, please, can you check with the AV unit? President, Councillor Coupe, could you please start afresh, as there is no translation to what you said earlier?
Of course, Mr. President. Yesterday we requested to be allowed to have some, to provide you with some oral submissions in relation to an earlier request by the civil party lawyers. That request was relating to the civil party impact testimony, which is scheduled coming Thursday and coming Friday. And yesterday we have sent you a few paragraphs, not from our closing briefs, but from our appeal brief. And in these excerpts in our appeal brief, we have criticized the judgment in the sense that approximately 255 times testimony provided during the civil impact hearings was actually used as evidence going to the guilt of the accused and the actions of the accused. We feel that although the trial chamber has clearly set out what the law is on this issue, that we cannot be sure that this will not happen again when at one point in time the trial chamber will write its judgment in this case. I would like to refer you more specifically to the arguments that we have set forth in our appeal brief, but that's the reason why our oral submissions could be relatively short. Having made these arguments, I believe that the proposed schedule by the civil party lawyers would not be an adequate way of dealing with the situation. Or the schedule on Thursday and Friday, as I understand it, the proposed schedule is 1 hour and 5 minutes per civil party. However, realizing that testimony given during the civil party impact hearings might in fact be used as evidence, we feel that the hour and 5 minutes proposed should be equally divided in time, in the sense that if the civil party lawyers are questioning the civil party and the civil party is actually testifying about events that are being adjudicated, we should have equal time. Let me, Mr. President, give you an example. If a civil party, for instance, says that she has suffered from her period in time in DK, and she's describing the ways that she has suffered, that of course is something that we would not anticipate asking questions to the civil party about. However, if the civil party gives testimony saying that she didn't have enough to eat, that children died because of malnutrition, that relatives were sent to re-education centers and disappeared, that is, as you might realize, evidence which goes directly to the crimes that we are discussing. If that is the case, then we feel we need to have the opportunity to cross-examine the civil party on the content of the evidence. Ideally, of course, we would not make such a request if it was 100% certain that at the end of this trial proceedings you wouldn't use whatever has been said by the civil party as evidence. However, as you have seen in our appeal brief, we are of the opinion that has not been the case. That's why, summing up our arguments and looking at the practicalities of coming Thursday and Friday, we believe that we should have half time of the allotted time, unless the civil party only speaks about her mental or physical suffering as such. Then, of course, we have the proper situation as anticipated by the internal rules. But, of course, we cannot anticipate what civil party is going to be saying or what the civil party is going to be testifying to. Therefore, our request is very concrete and I believe simple. From the start, we need to have half of the time, or actually the same time as the civil parties would have when leading the civil party. Thank you.
President, thank you. And Councillor for Case and Point, you have the floor.
Merci, Monsieur.
Thank you, Mr. President. I must say that we share a number of the Nunchia Defense's concerns. Thus far, as part of case 002/01, there has been a real distinction between hearings during which the civil parties made presentations regarding the facts and their personal experiences, and this phase in which civil parties express their sufferings are part of a more personal vision of what they felt, and it is important for the assessment of the degree of suffering and the impact on sentencing. The concern expressed by my learned colleague, which we share, is to know the status of these testimonies before this chamber. Will you consider them as a part of the assessment of the suffering of civil parties chosen by the civil party lawyers, and on which basis they were called to testify, or would they have a broader impact in terms of the evidence before us? As my learned colleague has said, our position as the defense is different. When they are talking of the sufferings of the civil parties, are they going to talk only about the sufferings, or will they testify to facts which will have an impact on what we should or should not do in terms of defending our clients? We need this to be clarified at this stage before we can determine whether we need more time to examine the civil parties, particularly in light of the Chamber's prior decision. Let me give the reference of that decision. It's E236/5 of the 17th of February 2013. That decision had to do with whether there's a distinction made between these kinds of hearings, or whether you are going to use elements from these testimonies and use them also for sentencing. This clarification is a very important, and I am requesting that you clarify this matter so that we can determine whether we can cross-examine the civil parties on purely factual issues.
President, thank you. And the Deputy International Co-Prosecutor, you have the floor.
Merci, Monsieur.
Thank you, Mr. President, and good morning to everyone. I have a few comments to make. First of all, the Nunchia defense has waited for the 31st of March this afternoon to talk about the impact of civil party hearings and the incidence of the alleged crimes on the civil parties. I know that what has been said orally before this chamber doesn't correspond to what has been sent to the parties. That is the arguments developed by the Nunchia defense in its appeal brief. Those arguments are a lot more radical than what we have heard today. In this tardy application, the Nunchia defense has relied on its late December 2014 appeal brief. It's not the arguments made in March 2015, but it has waited up to the 30th of March 2015 to make this application just before the civil parties are scheduled to testify. The debate is due tomorrow, just before the appearance of the civil parties, at a time when they are probably already in Phnom Penh. The memorandum of the chamber, E375, dated 17th of December 2014, and the defense had more than 3 months.
The International Co-Prosecutor, could you please repeat the EN number and please do it slowly? Thank you.
Oui, Monsieur le Président, je n'ai
Yes, Mr. President, I didn't give any ERNs. I just gave the reference of the Chamber Memo E315/1, dated 17th of December 2014, regarding these hearings for the expression of the suffering of the civil parties. Paragraphs 7 and 9 of the memorandum dated 17th of December 2014, the defense had more than 3 months to express its reservations on the form and content of those hearings, but it has waited until this late hour to do so. In the arguments presented before the Supreme Court chamber, the non-chair defense makes considerable reference to the practice in common law countries. It talks of Australia, Canada, New Zealand, the United States, Israel, and in these countries there are no civil parties. The role of victims is limited to that of witnesses, or it is viewed as a role that should come into play in hearings limited to the sentencing and not to the guilt of the accused. Here before this chamber, we do, however, have civil parties, and in one of the roles of the civil parties, they support the prosecution in proceedings against those presumed responsible. Common law jurisprudence is of no interest before this chamber and is not applicable. The chamber should recall that all evidence can be used. All evidence presented before the chamber can be used. Such evidence can be gathered in a legal and credible manner, and parties should be able to discuss them. So we have 2 situations before this chamber. 2 situations that are very similar. The first is one in which the civil parties are heard as a matter of priority on facts, on evidentiary issues, and all the parties can examine the civil parties. And the civil parties are allowed to express their sufferings in the end. In the interest of adversarial hearings, the chamber has always stated that in this second part, which has to do with the expression of suffering, if there are any new issues that impinge on the guilt of the accused, the parties may put questions to any civil parties. The second situation is the one we are facing on Thursday and Friday. The civil parties will express their sufferings and the incidents of crimes alleged. I recall that we've already debated this matter before this chamber, and the civil party lead co-lawyers and myself had explained that it is not possible to completely separate or dissociate the sufferings endured from the crimes alleged. In order to understand the sufferings of the civil parties, you have to explain the root cause of those sufferings and the consequences, that is the effects. This falls within the scope of the trial, and the defense is entitled to ask questions. These are evidentiary issues which the Chamber can rely on, including in its judgment. We should also emphasize the fact that as part of case 002/01, all the parties had the opportunity to ask any questions they wish to ask to the civil parties during the 4 days of hearings that were devoted to the suffering of the civil parties in terms of the crimes alleged. That was what, the 28th of May, 27th, 29th, and the 30th of May 2013, as well as the 4th of June 2013. We know that the time is limited, but questions were nevertheless put to the civil parties, both by the prosecution and the defense, regarding the contents of the crimes and not only on the sufferings phase. So the defense cannot say that it did not know that certain portions of the testimonies of civil parties regarding alleged crimes could and would be used by the Chamber in its judgment. For example, in the hearing of the 27th of May 2013, Son Arun, defense counsel between 1142 and 1157, put questions to the civil party Ron Pali, not only with regard to the suffering, but on the circumstances of the evacuation of Phnom Penh. And they also questioned the civil party on coercion and the use of violence. They put a question to civil party Yospal on the 27th of May 2013 for about 20 minutes from 15, 14, and 4 p.m. And the Chamber gave the defense more time to put questions to the civil parties on the fate of Lone Wolf soldiers at the time of the evacuation of Phnom Penh. This is not purely matters of that were incidental, but on facts of the case. So the defense continued putting questions to the civil party for 10 minutes. And I can give many other examples we saw during the 4 days of hearings, but the defense had a lot of time and latitude to put questions to the civil parties. And these questions had to do with the substance of the case. Now, Nunchia wants to eat their cake and have it. They want to challenge the civil party, challenge their testimony, and the evidence they will provide. At the same time, they are telling the appeals chamber that it is not acceptable that evidence adduced before this chamber should be used, evidence adduced during those days of hearings. That is essentially what transpires from the appeal brief. Today we are being told that we don't have time, and they want the chamber to clarify whether it intends to use such evidence in its, or rely on it in its judgment. Yes, it is possible to give the defense more time, more than the 15 minutes allotted to the defense. In case 002/01, the chamber has been flexible in the past, and there's no reason why it would change this practice. Nevertheless, to ask that the defense and the civil parties should have the same time is an exaggerated request, because we are talking of the suffering. They will focus mostly on the suffering of the civil parties and not on the facts. So the application of the defense is exaggerated when it asks for the same time allotted to the civil parties and perhaps to the prosecution and the defense. That is all I wanted to point out, Mr. President.
Monsieur le Président, juste une correction.
Mr. President, I would like to correct something.
President, thank you very much. You may now proceed. Civil Party Lead Co-Lawyer.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. I have a few comments to explain as clearly as possible. I hope the way that we have come up with this proposed schedule, and I would like to propose possibly a solution that may satisfy everyone's requests if the Chamber was to consider that these requests are legitimate. The three elements that guided our thinking in order to come up with this proposed schedule is, first of all, the fact that these hearings about suffering are the main way for the civil parties to participate in this trial and to explain why they are participating in this trial through the Civil Party Collective. And therefore, it is essential that at one point in this trial, we speak about the harm they have suffered. Moral harm, physical harm, and material harm that justifies that they are participating in this trial. And it's even more so important with regard to Trump Kok, because we have a very great number of civil parties that were admitted by the co-investigating judges for this particular segment. We have 51 civil parties who have been admitted and for this segment, so therefore it is very important to us to propose the testimony of the greatest amount of civil parties during these 2 days. And the second element that guided us was to preserve the special quality of these hearings with regard to the harm the civil parties suffered from, by making a distinction but also a link with the facts. I think that all parties agree that the harm and the facts are intrinsically linked, and it is necessary, of course, to speak about the facts, to speak about the harm. And I would like to react to the two examples that were provided by my colleague Victor Koppe. We believe that the deprivation of food is a form of harm, and therefore we will speak, or the civil parties will speak about this question of food when they will testify about the harm they suffered. We believe that psychological harm was also the result of the loss of loved ones. So when the civil parties will speak about the loss of their loved ones, it is clear to us that they should speak about the conditions in which they lost their loved ones. So, on the one hand, we agree with the parties to say that, yes, indeed, there's an intrinsic link between the facts and the harm suffered, and therefore it is necessary for these hearings to mirror this link, but we do not agree with the defense when we believe that it's the same thing. The fundamental difference is that the civil parties, when they speak about their harm, are speaking about what they experienced personally, directly, and only what happened to them. And they're not heard by the chamber about what they saw or about what they knew, but only about what they experienced, about what they lived through. So therefore, this, of course, reduces in a considerable way the scope of the facts they're speaking about before the chamber. And this is why it seems to us necessary for the other parties to only put questions on the facts, but the facts that regard the civil parties directly, and therefore the time should not be equally shared between the civil party lawyers and the defense. And the third element that guided us, of course, is the adversarial principle. We are, of course, it is in our direct interest to have the civil party testimonies on Thursday and Friday be debated in an adversarial way, in the most transparent way possible. Now, the question now that is raised is, how are we going to respect this principle with regard to this specific kind of hearing, the hearing about suffering? So what guided us to make this proposal are the words of the chamber, simply speaking. That is the memo that was sent to us last January, E315/1, in which the chamber keeps the right to give the possibility to the parties to question the civil parties if new facts are brought up, by the civil parties, or if allegations against the accused are formulated during these testimonies. And it's in paragraph 8 of this memo, E315/1, in which which you filed in December 2014, which explains this. In order to understand a little bit better what the Chamber means by new facts, we relied on a new memo which you filed last year. It's E267/3. It's a memo that was filed following the Kyusampon defense's request to to question a civil party again that had challenged its client, and you considered that it was necessary to consider new facts in relation to the victims joining as civil parties or in relation to the victims' information forms. And anything that was new in relation to these documents could therefore justify questions coming from the defense. So it is on the basis of these two memos that we made this proposal. And this proposal is indeed, as it's stated, a proposal. And we were waiting for the defense to make comments in relation to these proposals, and in particular in light of the appeal that the Nguyen Chia defense team as well as the Kyusampon defense team have filed. We did not know if the defense was going to make a request. It appears to be the case today. The Nguyen Chia defense apparently says that they do not have enough time to question the civil parties with regard to the facts, and I believe maybe that Kyusampon believes that the Chamber should be clear about what the Chamber wishes, but we consider that it's up to the Chamber to decide either to approve our proposal or to ask us to change it, or to decide if the time that we had proposed for the other parties is adequate or not. Once again, we believe that the more we respect the adversarial principle, the more we will benefit from this. It is not at all in our interest to prevent the other parties from expressing themselves in these hearings about the civil parties suffering. It's true that the time that we had planned for each civil party is limited. It's limited for everyone, for us as well. 40 minutes for each civil party, that's not much time. And we were obliged to take into account the shortened hearings because of the break at 11:30 upon Kyusampon's request. So this had essentially an impact on our speech time. And here again, we made a proposal. Now it's up to the Chamber to decide whether or not this proposal still abides by the principles of a fair trial and the principles of an adversarial trial. So, therefore, we informed ourselves as we were expecting the oral reactions, and we could make a proposal to the Chamber, possibly, which would be to start the questioning of two civil parties tomorrow afternoon, which therefore would allow the Chamber to have much more leeway in the management of the speech time for each of the parties. And if the Chamber is open to this proposal, we have identified already two civil parties that would be willing to testify tomorrow afternoon, which therefore would make it much easier to manage time and therefore to give more time for the defense to put questions with regard to the factual elements in the civil parties' testimonies. So we're quite flexible. So we believe that the proposal that was made addresses the memo and the instructions of the Chamber and complies with prior jurisprudence. And we respected the same model that was drafted last year in case 00201. But if you consider that this proposal should be amended, well, our request is that all civil parties be heard insofar that all of the civil parties are already in Phnom Penh, so we would like to be able to hear 8 civil parties during these hearings, and it seems to us that it's not exactly fair to give equal time to the defense, because what we're speaking about, once again, we're speaking here about the personal experiences of the civil parties and not what they saw or not what they knew back then. And therefore, we're proposing, finally, to show our goodwill to begin tomorrow afternoon with 2 civil parties so that we enjoy all of the time necessary to put the necessary questions to the civil parties. These are my submissions, Mr. President.
President, thank you very much. You may now proceed. Counsel for Mr. Kensampon.
Yes, Mr. President, I have a few small observations to make, or I would like to make a small correction in what I said. The decision I was referring to, E267/3, which my colleague also referred to, yes, I wanted to correct that small mistake in the number.
Thank you, Mr. President. I feel the need to react to both Deputy Co-Prosecutor and the civil party lawyer. I'm not quite sure if I follow the argument made by the prosecution about us being too late with this point. I would like to remind the Chamber that obviously our appeal brief was due on the 29th of December. That was the day that we filed our appeal brief and were able to fully develop our argument. So both parties, all parties are aware of this fundamental problem that we have. However, on the 16th of January of this year, in E336, we filed a request with the Chamber that has been already decided upon by the Chamber, which is called our request regarding certain practices to be undertaken when examining upcoming civil party TCCP 271, that is SAICEN. And you will read in paragraph 12 that we developed that argument already. So I think this argument is known to all parties, so I'm not quite sure if I follow the point of us being too late. What I would also like to point out is something that I haven't heard either from the prosecution or from the civil party lawyers, and that is that our analysis that we have made in our appeal brief, meaning that in the judgment civil party impact testimony was used as evidence 255 times. That is not being contested. That I find interesting. This means that we seem to be in agreement that whatever a civil party might say during his or her civil impact testimony is in fact evidence. And then if that is the case, then we have a serious situation. And if that is the case, we should fundamentally think what the law is. As you know, we have quoted the trial chamber itself when it set out its ruling on this matter. And I have been trying to be practical as to the division of time, but it doesn't change the fact that the law, or the rules, as indicated by yourself, is quite clear. Whatever a civil party is saying during civil impact is not evidence that goes to the fact. I see you not, Judge Fence, asking why, but that's how we interpret your ruling. And if we see it wrongly, then please enlighten us. What we can do, what we have done, is identify 255 instances in which the trial chamber, in case 002/1, used civil party impact testimony as evidence. That is what we believe the situation. If that is going to be the issue, not only in this segment but in coming segments, we need to have maybe a ruling from the trial chamber on this issue of big principle, I believe. And we should know what the situation is. If evidence given on food shortages, etc., is in fact evidence, then we need to have the opportunity, and we need to exercise our right to cross-examine the particular civil party.
President. What about your requests? What about the request of lead co-lawyers to hold the hearing tomorrow afternoon of two civil parties? So, what is your response to that?
It's maybe a methodological issue. I suppose we need to know what the law is, what the procedures are. If the trial chamber is of the opinion that whatever is being said by a civil party during impact testimony is in fact evidence, hence confirming the judgment, then we need to have time, and then it would be a proper suggestion to follow, I believe, from the civil parties to maybe start tomorrow and have equal time. However, if you, Mr. President, Your Honours, confirm your earlier ruling, then there is no place for any evidence being put forward during civil party impact testimony. And then, of course, we would do the same thing as we did in case 002/1 and only briefly ask some questions to the civil party. I might recall, and we also briefly mentioned that in our appeal brief, when Nguyen Chia was very sick at the time, 2013, he was requested if, despite his illness, we could nevertheless continue with having hearings on civil party impact. Because, as you've indicated, it wasn't going to be used as evidence. And at the time we said, of course, no problem, we can continue. But then, of course, we were quite shocked to realize that what was in fact said during his absence was used at times as hard evidence. And that is, I think, the situation that we are facing. Maybe before talking practicalities, we need to know from the trial chamber what the law is.
President, what about the defense counsel for Mr. Kil Somphon? What is your response to the request of lead co-lawyers to hold hearings of two civil party tomorrow afternoon? Because the lead co-lawyer mentioned already that the defense counsel for the accused want to have equal time to put question to the civil party who will come to express their impact statement. The chamber decided to hold 2 days hearing. And we have also considered the time reserved for parties to put some relevant questions. We have taken into account all factors, and as a result, we now hear the request from lead co-lawyer to hold the hearings tomorrow afternoon of two civil parties. So this matter concerns the arrangement of our court proceeding as effective as possible. So what is your response to that, counsel for Mr. Kil Somphon?
Mr. President, with regard to the time that will possibly be necessary for us to question the civil parties, well, I have a problem assessing this because, as you know, most times we are only facing testimonies of civil parties that are not very detailed or that are only in Khmer at times. So I have a hard time projecting how much time we will need. That's my first point. And in any case, what's clear is that if there are new elements that appear, or if elements that do not regard the personal experience of the civil parties, of course we will put questions. With regard to point 2, which is, are we opposed to the idea of coming tomorrow afternoon? Well, then I would like to rely to the Chamber's decision. We are here in Phnom Penh, and when there are hearings, well, we come. It's clear that the afternoon would have allowed us to go over elements that were not translated from the civil party documents that we just received. That's true. It would have been useful in that case for us not to not have the hearings in the afternoons today and tomorrow and yesterday. But of course, we will rely on the Chamber's decision as far as what the Chamber may consider is the most practical solution.
President, please hold on. International Deputy Co-Prosecutor, the DVD is running out, and we need some time for the AVs to change the DVD first. President, you may now proceed. International Deputy Co-Prosecutor.
Thank you. I will be short. We have no objections to manage the time in such a way that all civil parties, or in any case the 8 that are scheduled for tomorrow, can come. I think it would be a bit hard to say right now, well, no, you cannot come now. So maybe tomorrow, on an exceptional basis, we have no problems with having the hearing tomorrow afternoon. Now, with regard to the documents in one single language, I don't think that with regard to the 8 civil parties, it should be a big issue. I have been able to generally find all the documents in English and in French, if you look carefully in Xylab. So the Kyrgyzstan defense could also come see me if they have a hard time finding certain of the documents in French or in English. Thank you very much. Well, simply a small comment, Mr. President, and thank you for giving me the floor again. As Mr. Koppe suggested, and concerning the way that you have used the statements on harm, does not concern the discussion we have today. This is a discussion that will happen at the appeal stage. Of course, we're going to answer point by point the points in the Nunchea appeal brief. We disagree with much of the analysis that is done with regard to the specific points, but we don't believe that it's useful to have this debate today. And I'd like to say again that, essentially speaking, we believe that the schedule as proposed meets the requests as well as the previous jurisprudence of the Chamber. And as a side point, if you believe that it's necessary to have more leeway for the parties to organize their questions, well, we have already identified 2 civil parties, and I can give you the names now or by email after the break, 2 civil parties that are willing to come testify tomorrow afternoon.
President, thank you very much. You may now proceed, Judge Fence.
Yeah, this is about basically what the appeals brief is saying. And while we are clearing not at appeal stage, I've wondered about the possible, mistake that has been made and might have led to wrong conclusions. I'm referring to 189, paragraph 189 of the appeals brief, where I think the core argument is quoted, what the Chamber has said. But the fact is, this paragraph or this ruling by the Chamber referred to character witnesses. And it's very clear if you look at the reference. To quote one by one what we said in the decision, you actually quote 72.3 about character witnesses. Now, obviously, character witnesses' sole purpose is to enable the trial chamber to determine, etc., etc. But that's about character witnesses. Now, then you quote all kinds of international jurisprudence. I'm not going into this. And in paragraph 193, you say, had the trial chamber not informed the accused that victim impact testimony would be used only to determine sentences and reparations, the defendant would have objected, etc. Now, provided this is not a wrong reference, wherever did we tell the defense that victims' impact testimony would only be used to determine sentences? That would perhaps help if we could get that clarification.
I, of course, don't expect the trial chamber to readily accept errors of law or fact. I'm not now at the position to go standing on my feet, reply quickly to what you're saying. But I do note another reference which was quoted in paragraph 189. And that's also, that's how we understood it, and that's how Nguyen Chia understood it at the time. That's why he was asked if it's okay not to appear while civil parties were giving civil impact testimony. That's what our understanding was, and again, if you're saying now your understanding was wrong, then we know that. Then if having said that, having heard that, then of course our request to have equal time becomes much stronger. And maybe the other parties can correct me, but I think this is how everybody understood the way civil party impact testimony was to be treated. If we are now saying, if we're now hearing you saying, well, on what did you base that? Then, we have I suppose, another situation. I agree that this is an issue that should be dealt with at appeal stage. But if you're now saying, yes, whatever is being said during civil party impact testimony can be used as evidence, then the situation right now to us is crystal clear. We need at least the same time as the other parties.
And my next question is a practical one. And this is to the co-lead lawyers. Do we understand correctly that basically all the civil parties you have suggested or put forward for suffering are also fact witnesses, meaning can say something about the facts?
Well, I cannot predict what they're going to say. All civil parties were admitted as direct victims of Tram Kok. So potentially, all of them may, in their testimonies, bring up questions that may be questions of fact, or that could be considered as such.
President, you may now proceed. International Deputy Co-Prosecutor, you are the last person to speak today.
I just wanted to respond quickly to the issue that Mr. Kopi has raised. I have a different recollection than him, and I'm in the process of searching the very huge transcript of these proceedings, but I remember being in this court, this issue being debated about whether victim impact testimony could be used not only for that but also for facts, and a ruling being made that it would be used, and that we all had that understanding, very clear understanding. I remember being rather outraged when I saw this argument in the Noonshea brief. I will search through the record and find where this discussion took place, because I think it is an important point, but I completely disagree with what the counsel has said here. Our understanding, and I believe there was a debate about this in this courtroom, was that victim impact testimony could be used for that purpose.
President, the chamber told already that the International Deputy Co-Prosecutor was the last person to speak today after other parties. The chamber, thank you very much for your submissions in relation to the request by counsel for Mr. Nguyen Chia. The chamber will take all information into account and will issue a decision in due course. And the chamber also will take into account and decide the request of a lead co-lawyer in relation to the hearing tomorrow for two civil parties. Actually, we scheduled to hold hearings for the 8 civil party on the 2nd and 3rd April 2015. The chamber will take all the relevant information into account, and we will inform parties via the senior legal officers of the trial chamber. The hearing today comes to an end, and it will resume tomorrow on the 1st April 2015, starting from 8 a.m. And the hearing tomorrow will continue to hear the testimony of Richard Dutchman via video link from the USA. Parties are invited to be in the hearing as scheduled. Security personnel are instructed to bring Mr. Nguyen Chia and Mr. Khieu Samphan back to the detention facility and have them returned here before 8 a.m. tomorrow. The court is now adjourned.